Is Jay-Z innocent or is he just deflecting? Because the way that he is filing these motions back to back and focusing on a lot of the misconduct of Buzbee, I don't know if it really is going to show in court that he's not actually guilty. Now, I will say that some of the facts that have come out in the recent NBC News interview with the accuser, I will say that some of those facts don't quite add up. But when we go through this document today, we're going to see that a lot of this is an attack on Buzbee, which I don't deem as being a bad thing or a good thing. I guess attacking the attorney is better than attacking a potential victim. But it almost seems a little bit off topic for me, and like he's litigating the case before we actually get into litigating the case, which again, I guess it makes sense because he's trying to be dismissed from the case. If you guys don't know what I'm talking about, Jay-Z has filed a request for an emergency hearing to determine whether this motion, or sorry, him being named in the complaint, need to be striked. He definitely just let go of his, she can't be anonymous no more. Y'all just need to remove me from the complaint is what he's saying now. And he is also saying that Buzbee has done some wrong things in the case, which requires for the court to make a ruling early on in the case that Buzbee is to preserve over the evidence, that any evidence that the accuser may have in the case. So if y'all have been following along, y'all know that Jay-Z was added to this complaint with Diddy, where they're accused of saying or R-wording a 13-year-old girl back in 2000. And Jay-Z was named in the complaint on December 8th. And since he's been named in the complaint, he's been filing motions back to back. This is like the second week he's been involved in this, in these accusations, and he's filed multiple motions. And now he was asking for an emergency hearing today. That did not happen today. The court has not made any rulings on this motion, but Jay-Z is throwing shots. And I'm going to say it right now. I think it was a bad idea for Buzbee to come after Jay-Z in this case, because Jay-Z is bringing up all of Buzbee's dirty laundry. And honestly, I would rather him focus on attacking the attorney than attacking the accuser, just because it sounds like this accuser has actually been through quite a bit of things, although it may not have been with Diddy and Jay-Z, but it sounds like she's been through quite a bit of things. But he is bringing up all of his dirty laundry, including lawsuits where Buzbee's own clients have sued him for stealing their money. So we're going to get some of the questions that we've had in the past about how are these lawsuits being paid for. We're going to get some of those questions answered today. And we're going to talk about why are Buzbee's clients suing him. I think we can all guess why they're suing him just based off the lawyering that he's doing so far. But we're going to talk about a little bit about some of his current cases that he has going on, because apparently he has a bunch. In addition to the FBI investigation, Jay-Z didn't even have to touch on that in this motion, but I digress. If you guys are new here, we are live. Make sure you are dropping your chats in the chat box to let us know what you're thinking as we go through the documents and we talk about the case, and we'll cover the chats at the end of the live stream. If you're watching on the replay, make sure you drop your thoughts and your comments down in the comment section, and I will reply to as many as I can. And of course, we're live. And if you're watching on the replay, you're on the replay. But don't forget to hit the like button and subscribe if you're not already subscribed. We cover celebrity cases on this channel, or just cases that we find interesting. And we are going to start my Reddit reads. I know I said that like a couple months ago, but we're going to start doing it. Anyways, let's go ahead and jump right into the action with Jay-Z asking for an emergency hearing. Now, Jay-Z asked for this emergency hearing to have the court order that Buzbee is required to preserve evidence. Although this is a 24-year-old case, the incident happened 24 years ago. And he's also asking that he just be dismissed from this case, and that the amended complaint, which names him as one of the defendants, also is stricken, so it no longer exists in the court file. He re-explained some of the stuff that we've already covered in the letter on, what was that, Sunday when we covered that? But he goes into a little bit more detail in the bad acts that Buzbee has been doing. Like I said, this is the case where a Jane Doe anonymous person has sued Diddy and now Jay-Z. And I think they kind of gave away who the female in the room was. They don't come right out and say that it was the female in the room, but they do note this celebrity. So y'all can let me know in the chat who y'all think it is, or in the comments who y'all think it is. It's going to come out in this document, but I think they kind of blow the cover of the female celebrity that they are claiming is in the room through this document. Like I said, don't quote me on it, but I just don't see any other reason of bringing her up other than to allude to her being the one in the room during this alleged attack that the accuser is saying. So let's jump right into it. But of course, Bri did not share the screen that we need to see. So let's actually do that part and jump right into it right about now. Okay. So his preliminary statement: admissions by the plaintiff in a darning admission by her own father in a December 13 revelatory NBC interview casts yet further doubt on a claim that was obviously false from the start. Y'all know me. I don't like the absolute language. Like, it's obviously false. The facts don't add up, but I don't like the absolute statements in pleadings, and they taught us not to do that in law school, so I don't know where these people went to law school. But anyways, the timeline, location, and occurrence of the events alleged in plaintiff's complaint are rendered impossible by these admissions. She claims her father picked her up after the assault. Okay, this is one thing I noticed when I was reading this. They actually took their time in filing this complaint. Remember, they told us last Friday they were going to file this complaint. They didn't actually, motion, and they didn't actually file it until yesterday. And so I thought it would be pristine. First typo very early on in the document is that her dad ever taking the 5-hour trip. I think it's not a super big mistake, but we like to call out the mistakes on this channel with the lawyering. So that he never remembered taking a 5-hour trip. She claims she spoke with musician Benji Matten that night. He was not even in New York. She claims the assault took place at an after party hosted in a private residence. Photos show Mr. Carter at an after party at a nightclub. When pressed by NBC, plaintiff was forced to admit, I have made some mistakes. I may have made a mistake in identifying. Not all of the faces there are as clear. And even that she was guessing about key details, including the time it took to reach the venue. What is more, she admits she does not have a single corroborating witness over the last 24 years. Now, what that's going to do is going to make it hard for her to reach her burden of proof. She's just going to say, they did these things to me. Please believe me. We talked about this on Sunday. Then Jay-Z and Diddy's attorneys are going to get up there and say, don't believe her. She doesn't have anyone to second what she says happened. Her dad says that he never picked her up from 5 hours away. And also, don't forget, she has had a head injury since this incident. And she claims that she was potentially drugged or drunk during this incident. She has already admitted that she's made some mistakes, and that the faces, the identity of the people that she's accusing or saying that she talked to, that's not even clear. So how are we supposed to only believe, while other parts of her story are not accurate, we're supposed to believe that Jay-Z and Diddy doing this to her with this female celebrity in the room is the only accurate part of the night? I don't think it makes for a good case, and Buzbee really should have vetted this before he filed the complaint. Plaintiff's unsupported allegations crumble under scrutiny as the evidence and lack thereof reveals glaring inconsistencies and outright impossibilities in her story. Her account describes a jumbotron at the scene of the Video Music Awards. This is new information, y'all. We didn't have this on Sunday. So she talked about the jumbo screen at the VMAs, but according to NYPD sources and MTV producers, no such jumbotron existed, which adds to the inconsistency. I remember watching award shows, and they would have little TV screens inside of a building that you can watch from outside. Maybe that's what she was talking about. But when she says a jumbotron, she's going to have to elaborate on what she meant by jumbotron. So that was some new facts that they're throwing in there. MTV applied for a permit to install one, but was denied. She references a house that supposedly fits the description of the location of the alleged assault, but no such house exists. The plaintiff's allegation become even more dubious when considering the nightclub evidence. Photos from the night in question show Mr. Combs and Miss Jennifer Lopez. Why are we talking about Jennifer Lopez? Are you hinting, Jay-Z, at Jennifer Lopez is the alleged other celebrity? And if you are, how do you know? Y'all let me know if I've been missing something in the press and if that's been released before. But this is the first time I'm seeing her name come out in court documents. And I only follow court documents, not news articles, right? So Diddy and Jennifer Lopez were at two different parties. Why are we talking about Jennifer Lopez? Is she the female celebrity? Because remember, she's not named in the lawsuit yet. She's not. They were at both Lotus and Twirl clubs in New York. NBC reported that photos separately showing that Mr. Carter was at Lotus following the VMAs, taken together the factual inconsistencies, timeline impossibilities, and lack of corroborating evidence make plaintiff's allegation in the first amended complaint wholly unreliable. Not only do these extraordinary inconsistencies undermine plaintiff's case, they highlight severe misconduct by her counsel, attorney or Anthony Buzbee and the Buzbee law firm. Let's get into ripping into Buzbee, as we like to do on the channel. Unable to escape the foundational cracks in plaintiff's story laid bare by the NBC interview, Buzbee was forced to backpedal, repudiating the very allegation he signed his name to. In an attempt to deflect from his own failures, he foisted blame on another law firm. This is creative writing, y'all, claiming the case was vetted before it was sent to him. And so concerned is Buzbee that he is now having his client sit for a polygraph. He didn't say he was going to make her do a polygraph. He said that she offered to do a polygraph to prove that she was telling the truth. So that's a bit of a stretch for me, but okay, Jay-Z, we'll see where you're going. The takeaway is obvious. Buzbee failed to undertake a reasonable inquiry into the facts before filing the complaint and then amending it to assert a claim against Mr. Carter, despite an affirmative duty to do so under Rule 11. But that was just one step in his cavalcade of misconduct, or cavalcade of misconduct. Though he has signed his name to pleadings and other documents filed in the case, Buzbee has declined to seek admission to this court, apparently seeking to circumvent the court's authority to enforce Rule 11. Buzbee's rule breaking also extends beyond this action. He has a long history of abusing the legal process and shirking ethical responsibilities. In a case in California Superior Court, the case filed by Jay-Z, so I mean, I don't know how supporting it is, but in a case filed by Jay-Z, for instance, Buzbee was admonished. Oh, never mind. Erase that. This wasn't the one filed by him. He does mention his case later on, though. Buzbee was admonished by a judge for violating pretrial rulings. How is he practicing in California? He's licensed in California too? This man is everywhere. His freaking firm is in Texas. Why are you practicing in California? Like, what is going on? And a federal court in Texas rejected a fee arrangement orchestrated by Buzbee and his law firm because it violated public policy. And we're going to get into what that actually was a little later on. The fundamental inconsistencies in plaintiff case revealed in the NBC interview, coupled with Buzbee's chronic inability to follow the rules in this case and others, create a substantial risk that Buzbee will destroy evidence damaging to plaintiff's case, including evidence of his own misconduct, impairing the integrity of the judicial process, and order immediately mandating preservation of all evidence relevant to this case is necessary to ensure that Mr. Carter has a full and fair opportunity to present his defense against plaintiff's fictitious claims. That Buzbee is not admitted to this court and thus is apparently attempting to avoid its disciplinary authority only underscores the pressing need for such an order. I don't like how that sentence was written, but it is what it is. For the same reasons, all of plaintiff's allegations about Mr. Carter are scandalous, warranting striking them from the first amended complaint. I mean, they're accusing you of doing something. I don't think you can just strike it for that reason. Like, scandalous, if they're just saying you're a pedo, then yeah, we could strike that because he hasn't been proved to being a pedo, right? But saying that he did these things to you are not necessarily scandalous, but you can say that they're false, and that's why they should be stricken. So we're going to get a little bit deeper into Buzbee's misconduct, which is a very highlighted part of this motion to have this emergency hearing, which again was not granted. They wanted to have the hearing today, and I guess the court just didn't get to it. I'm not quite sure what time this was filed yesterday, but there was no hearing. There are no orders in place. And I doubt that the hearing happened today. I feel like we would have heard from a lot more people that it actually went forward. So let's jump into Buzbee's misconduct in just this lawsuit, because he has a whole bunch of misconduct coming up. So this is what Jay-Z is saying Buzbee did wrong in this lawsuit so far. Buzbee filed this lawsuit on October 20, 2024 against Mr. Combs and his associated businesses on behalf of an anonymous Jane Doe plaintiff. The initial complaint alleged that Mr. Combs, along with another unnamed male celebrity, R-worded plaintiff, at an after party held at Mr. Combs' home following the VMAs. Rather than name Mr. Carter as a defendant when the original complaint was filed, Buzbee resorted to a campaign of extortion seeking to extract an exorbitant sum in private mediation and threatening to go public with false and outrageous allegations that Mr. Carter R-worded multiple minors unless Mr. Carter acquiesced. Mr. Carter refused. It was only after this attempt to squeeze Mr. Carter that Buzbee filed the first amended complaint, adding Mr. Carter as a defendant and alleging that he was the previously unnamed celebrity. Now, we've talked about this on this channel before. Usually when you're naming people as does or anonymous in a complaint, it's either because you don't plan on suing them or you don't have enough information on them to be able to identify them, which can include not having the right address or the right attorney or whoever to serve, or not knowing their actual legal name. Like if they only knew Jay-Z as Jay-Z, but they didn't know that his legal name was Sean Carter, they might hold off on filing against him and they might list John Doe's, Jay Doe's, or I guess John Doe for him. They might list that instead of actually naming him in the complaint. Jay-Z is alleging that Buzbee was going to keep him unnamed if Jay-Z would have paid him. And since Jay-Z didn't pay him, he put him in the lawsuit, which was threatened allegedly in the letters that was sent by Buzbee's law firm. Now, what I would like to see, which no one has leaked yet, Jay-Z, please attach these letters. Are we going to do it in the California case? Do we need to check on that? I would like to see the letters that was sent to him. I really would. Maybe I need to check the California case to see if any of those were added to the file yet. Okay. The First Amendment complaint alleges that on or around September 7, 2000, plaintiff attended an after party in New York City, purportedly hosted by Mr. Combs at a large white residence with a gated U-shaped driveway and a large living room or foyer. At the after party, the First Amendment complaint alleges plaintiff recognized many celebrities, which included people like Fred Durst, Benji Madden, and others. The First Amendment complaint then alleges that she was drugged and then SA'd by Mr. Combs. The fact also alleges that Mr. Carter was the previous unnamed male celebrity B, who also purportedly SA'd plaintiff. After the incident, plaintiff allegedly left the party and went to a gas station where she called her father, admitted that she had lied about her whereabouts, and asked him to pick her up. Plaintiff's father then purportedly arrived to pick her up shortly before dawn. Just 5 days before Buzbee filed the First Amendment complaint containing these scandalous allegations, NBC News published a story containing excerpts of interviews that its reporters held with plaintiff and her father and presenting other information that severely undermines the merits of the lawsuit. Okay, 5 days after he was added. I thought they said before. So 5 days after he was added, NBC published their interviews and let us know that the facts are not lining up to basically implicate Jay-Z or to basically implicate that this incident ever happened, ever. Not only just Jay-Z, but maybe not even with Diddy. But right now, Jay-Z is only asking for him to be removed. He ain't asking for Diddy to be removed or the whole complaint dismissed in general. He's just asking for the First Amendment complaint to be dismissed. And basically the first complaint stands, which only lists Diddy and his businesses. Okay. For example, NBC reported that the photos of Mr. Carter from the night of the purported assault shows him at a nightclub in New York called Lotus, which has no resemblance to the white residence, with a U-shaped driveway and a large living room described in plaintiff's fact. One other fact that they could have added in there is that Buzbee also in the interview said they're never alleging that the plaintiff was at any of these clubs. They don't know where that fact came from, they don't know where it came from because there's actual photo evidence that they were at the club. So she's never alleged that she went to a club. She is sticking to that it was a residence. Okay. So I think that would have been good to add in to this position as well. Photos from that night shows that Mr. Combs and Ms. Lopez attended parties at two nightclubs on the night in question, Lotus and Twirl. Again, why are we talking about Jennifer Lopez? Is she the alleged celebrity female? Further, despite being sure she talked to Benji Madden at the after party about his tattoo of the Last Supper because she has a religious background, so it was something to talk about. Mr. Madden was never there. So your facts are not adding up, and basically Jay-Z is not necessarily accusing the accuser, but accusing Buzbee of not properly vetting the claims. Like, how did you know these inconsistencies existed? And the thing is, how did you not know these inconsistencies existed before you signed your client up to do an interview? Like, why would you agree to an interview so that she can make statements that could be used against her? Who is she, Alec Baldwin, making statements before a criminal trial? This is not criminal, but why? Did you not learn anything? Did you not learn anything in law school? Why are you putting things on a record? Girl, come on now. He did not attend the VMAs. He did not attend the purported after party and was not even in New York at the time. Instead, he was halfway across the country in the Midwest on a tour with his band Good Charlotte. Finally, though the First Amendment complaint alleges that plaintiff called her father to pick her up from the gas station following the assault, he denied that happened. This denial is darning. In fact, he told NBC he was unaware of his daughter's assault allegations until the week he was interviewed. So he didn't know about this incident that happened 24 years ago. He doesn't recall picking her up from it, and he didn't even know it happened until last week. That's not going to be helpful for your client, Buzbee, in trial. And why didn't you talk to the dad to corroborate the story before you filed it? And not only before you filed it, okay, maybe you messed up, you filed it believing your client, believing she was telling the truth. But then you turn around and you signed her up for an interview before corroborating the facts. Why? Why would you do that? I don't know why you would do that, but he did it. Okay? He did it. Let's jump back into it. Okay. NBC reported that he has no recollection whatsoever of picking up plaintiff on the night of the VMAs, and plaintiff and her father were living in Rochester at the time, which would have required her father to drive more than 5 hours from their home to pick her up on the night in question, an event that no father would forget if it actually happened, which is true. You would remember driving 5 hours to pick your daughter up in the middle of the night or early morning, whatever you want to call it, and then driving 5 or 6 hours back. Her father admitted as much, telling NBC, "I feel like I would remember that, and I don't. That's something that would definitely stick in my mind." Her father recalled one instance where he picked plaintiff up in the middle of the night, but he said it was a local drive in Rochester. So not in New York from Rochester, 6 hours away, right? Moreover, Buzbee effectively admitted to NBC that his firm failed to conduct any investigation into the merits of plaintiff claims prior to filing extraordinary allegations of child word against Mr. Carter. Buzbee seeks to shirk his Rule 11 obligation and foist blame onto another law firm for the glaring inconsistencies exposed by the NBC report. Rather than conducting his own due diligence to vet his client's claim, Buzbee merely relied on the purported vetting of another firm, telling NBC Jane Doe's case was referred to our firm by another who vetted it prior to sending it to us, but no one from the other firm signed the pleadings in this case. Buzbee did. His failure to investigate the claims violate Rule 11. And why did this firm, Buzbee, did you ever think of this? Why did this firm punt it to you instead of taking it on themselves? If it was this big money pit, right? Why would they pass it on to you? Maybe allegedly because they know you would get the facts necessary in order to make it fileable. This is allegedly, this is opinion, this is things that have been thrown out there. This is what you're being accused of in this motion. It's not me. I'm not saying it. But it sounds like you have been known to stretch the truth to get the cases into court. Okay. All right. So let's jump back into it. Further, as explained in the letter that Mr. Carter filed with this court on December 13, 2024, in the more than 8 weeks since he signed the initial complaint in this case, Buzbee has failed to seek admission to the court pro hoc vice in evident attempt to avoid the power of this court to enforce Rule 11 and other rules against him. I don't think he needs to do pro hoc vice because he is actually licensed in New York, but he does need to actually apply to basically practice in the court. You can't just walk in. I can't just walk into a New York court and be like, I'm an attorney in California, let me file a case. Like, I can't do that. You're not allowed to do that. Anyways, let's go on to the next part of the what did I just do? Okay, sorry. Nothing for y'all, but I messed some stuff up back here. Anyways, Next, we're going to go into Buzbee's misconduct in other lawsuits. Why is this relevant? I don't know, but Jay-Z is going to make it relevant. JK. It's relevant because it supports their reasoning why the evidence need to be preserved, because he be effing up and being misleading in other cases. So let's see. Buzbee's gross violation of Rule 11 in this case and his failure to comply with the court's admission requirements are just the most recent examples in a long line of litigation misconduct. Don't forget, we have already talked about how Buzbee allegedly had an FBI investigation against him. He had clients suing him. Now Jay-Z is accusing him of doing misconduct in other lawsuits, not just this one, okay? For instance, Buzbee and his firm were recently accused of violating the rules of professional conduct by 3 former clients for his deceitful misconduct. And I do actually have those documents of what they're accusing him of. So he has a misappropriation complaint, another misappropriation complaint, both filed in December this month. And then he has a malpractice summons or complaint against him from November of this year. So he's been up to a lot of things in this past year. And I kind of wonder, and these are just thoughts, speculations based on what's being accused of him. I almost wonder if this is like a rob Peter to pay Paul, like you're getting sued or you knew you were going to get sued by all of these other people. So then you start filing all these lawsuits to try to get some money out of Diddy and other celebrities. I would be curious to find out, because when y'all hear what he was doing to these people in these other lawsuits, like, y'all, if you're a fan of Buzbee, you're not going to be a fan of him anymore, assuming what's being asserted in these complaints are true. And based on the behavior that I've seen from Buzbee so far, I do think that the allegations are true, but that's my opinion, right? What is more, according to a former client of Buzbee and the Buzbee law firm, dropped her as a client after she resisted the firm's efforts to pressure her to adopt false narratives of her experiences as a victim of trafficking by celebrities unrelated to this case. Again, this is something that Jay-Z put into himself. An anonymous source called his attorney's law firm and said that Buzbee did these things. So I don't know if we can all the way trust that, but it is a thing. Specifically, the Buzbee law firm pressed her to confirm that she was drugged, held down, pushed, and physically assaulted. All false details. Moreover, she was repeatedly asked for a connection to Mr. Combs, though she made clear her case was unrelated to him. And already in this case, he violated Rule 3.4 of the New York Rules of Professional Conduct, prohibiting attorneys from threatening to present criminal charges solely to obtain an advantage in the civil matter by making such threats to Mr. Carter to extract a settlement prior to bringing frivolous claims against him in the First Amendment complaint. Now, I don't remember reading that he threatened criminal action, but I do remember reading that he threatened to add him to this lawsuit. I'm gonna have to go back and see if that was a thing, but this sounds like just adding a little sugar on top to me. I don't remember it. That doesn't mean it's not true, but I don't remember him threatening the criminal action. But nonetheless, let's go on. Buzbee also has a track record of employing suspect tactics to gain an unfair advantage in the course of litigation. Because Buzbee frequently serves clients on a contingency fee arrangement, he has a personal stake in the outcome of his cases and has demonstrated his creativity in stepping over the line to promote his own interests. So, contingency, we talked about this a couple streams ago, is basically where the lawyer upfronts all the costs and then you as the plaintiff reimburse them at the end of the case. I would suspect that's what he's doing in these cases. We've seen this in the allegations against Tom Girardi, where he was taking loans, or his firm was taking loans from litigation loan companies, racking up all of these bills and then paying it off the debt with the wrong plaintiff's money. So they basically front the money. Either they have it or they take out a loan. And then at the end, when they win, they basically get the money from the client. And although you might have been awarded $300,000, you end up only with, in some of the cases that's being alleged against him, it's $5,000 because Buzbee has charged a lot of money in loans and expenses and attorney's fees and medical payments, all the things, right? So out of the $300,000, all you walk away with $5,000 when you're the one with the severe injury. So that's a contingency case. I would guess that these cases are also contingency because they seem to fall under personal injury, and personal injury are usually contingency cases rather than a client paying a retainer up front and having to pay that person by the hour. You don't pay them by how much work you did. They get a percentage of whatever the award, the monetary award is. In one notable case, a federal court invalidated a referral agreement between Buzbee and a known fact witness in the case as invalid as a matter of public policy, which entitled the witness, a known witness in the case, to 15% of the gross attorney's fees awarded to Buzbee's client, awarded if Buzbee's client was victorious. You cannot do that. You can pay witnesses a witness fee. Has to be reasonable. You're probably, if it's just a lay witness, maybe $25, maybe their wages for the day. If it's an expert, you're more looking at paying them $10,000, $20,000, whatever their fee is, right? But you do not give them a percentage of whatever your attorney's fees are, because that can sway their testimony. And, oh, well, if I say that I for sure saw her pull the trigger, I'm going to get more money because the attorney is going to get more money. So I'm just going to say I saw her pull the trigger, So you can't do those kind of things. And what do you call it? Jay-Z is accusing Buzbee of doing that. And actually, no, the court accused him. There's actually a case where you can read it that he did do that. And they said that is against public policy. I don't know the public policy reasoning behind it, but we can probably look it up. And another unscrupulous tactic, in order to get a case heard in a favorable venue, the Buzbee law firm submitted venue pleadings in a client affidavit characterized as, at best, incorrect and at worst, fraudulent. So he filed an affidavit on behalf of his client that was not accurate or fraudulent. After the defendant's counsel notified Buzbee's firm that his clients misrepresented facts that affected the trial court's venue determination, Buzbee unilaterally non-suited the case and refiled a substantially similar case in another favorable venue. So essentially, they filed a case, they got called out, they unfiled it, and then just filed it somewhere else, which you're not supposed to forum shop. Finally, Buzbee has demonstrated a lack of respect for and willingness to violate judicial orders. In one case, Buzbee baselessly accused former baseball player Scott Erickson of being to blame for a murder while representing criminal defendant Rebecca Grossman. Grossman. I'm gonna go with Grossman. He falsely claimed Erickson was the driver who hit and unalived two young boys and was hiding in the bushes after the fatal act. Despite no evidence to support this assertion, prosecutors accused Buzbee and his team of unethical behavior, stating they are making a mockery of the judicial system or the justice system. The presiding judge rebuked Buzbee, declaring, "We cannot have the defense violating pretrial ruling and expose the jury to evidence that contradicts those rulings," and reprimanded him for his conduct, stating that if it continued, the court would consider financially sanctioning Buzbee and reporting him to the state bar. Okay, what is the legal standard to have evidence preserved? And basically say all participants of a lawsuit, including attorneys, have an unassailable duty to preserve evidence that might be useful to an adversary. So that might be useful to Jay-Z. Where there is a risk of destruction of such evidence, the court may issue a protective order directing preservation of the evidence. Courts often apply a three-factor called a Capricorn test, which involves 1, the level of concern that the court has for the continuing existence and maintenance of the integrity of the evidence in question in the absence of an order directing a preservation of that evidence. Sorry, y'all, we are going on to why we need to the arguments in the case, and I forgot to mention that to y'all. Okay, number 2 in the test is any irreparable harm likely to result to the party seeking to the preservation of evidence absent an order directing preservation and the capability of an individual, entity, or party to maintain the evidence sought to be preserved, not only as the evidence original form, condition, or contents, but also the physical, spatial, and financial burdens created by ordering evidence to be preserved. Let's get into the reasoning why Jay-Z is saying that it needs to be preserved in this court. That was all a bunch of case law. We're not going through all of that. Okay, so the first reason why they think it needs to be preserved. First, the NBC News report the NBC News report makes it extremely likely that Buzbee failed to properly vet the claims he made in the complaint in this case, a clear violation of Rule 11. His willingness to blatantly violate the core ethical obligations of all attorneys raises the serious possibility that he will seek to destroy evidence documenting his action. Yeah. To not vet the claims and then do like an outside interview proving that the claims are not entirely accurate. Like, you just wrote this document 2 months ago and now her story is changing, or not changing, it's just inconsistent. It doesn't add up. The facts of what exists, the picture, the actual evidence doesn't add up, right? Second, Buzbee's utter disregard for his obligations as an attorney, namely his violation of the rules governing admission to the bar of this court and his violation of Rule 11, raise a significant possibility that his law firm has inadequate retention procedures in place, granting the basically, since they're not actually signed into the court, they might just abandon the case and not be subject to the court's jurisdiction to punish them. Third, as explained in Mr. Carter's December 13 letter to the court, Buzbee is apparently attempting to circumvent the court's authority to enforce Rule 11 by refusing to seek admission to the court, despite the fact that he has signed the complaints and other filings. Fourth, Buzbee's disregard for the rules in other cases underscores the need for a preservation order here. For instance, in a federal case in Texas, Buzbee orchestrated a fee arrangement with a known fact witness that the court struck down as invalid as a matter of public law. Like, you're paying them based on what you receive. So if you receive $100,000, this plaintiff gets $25,000 if they testify to what you want them to testify. But if you only get $10,000, that plaintiff only gets $2,500 if they testify to maybe truthfully, right? That may not all the way line up with what Buzbee wants to have testified. That's the implication that occurs when you do that kind of fee arrangement. And the courts found that it was improper and against public policy when he did it. And in another case in the California Superior Court in which Buzbee was defense counsel, the judge admonished Buzbee for his misconduct, stating this shouldn't be happening. As we go forward, we can't have the defense violating pretrial rulings and expose the jury to evidence that contradicts those rulings. Finally, Buzbee and his firm have been sued for extortion in California. This is the lawsuit filed by Jay-Z. So I don't know how much this supports the argument because it's literally a motion filed by you, but it is a thing. It's pending, right? Allegations related to his conduct in connection with this case. Buzbee and his firm therefore face personal liability for their conduct related to this lawsuit, creating a financial incentive to destroy evidence that is unfavorable to their clients. So they don't want them finding anything that would help Jay-Z prove his case, because they're being sued personally and I believe professionally as well. And so they may have to pay versus their client having to pay, especially in light of the NBC News allegations and Buzbee's history of blatant violations of the rules, including his failure to seek admission in this case. Anytime in the last 2 months, Mr. Carter faces a substantial danger that relevant evidence will be destroyed absent a preservation of the order. And then we go into absent a preservation order, Mr. Carter's right to conduct full discovery will be irreparably harmed. Basically, if Buzbee is allowed to destroy evidence, he may not be able to actually prove his case. And he says this case is affecting himself, his family, his business, everything. And he needs to be able to prove himself innocent. And then the burden on Buzbee to preserve the evidence is negligent. As we talked about earlier and we talked about on Sunday, she doesn't have any evidence. She already said she doesn't have a corroborating witness. The person that drove her to the scene allegedly is no longer alive. Her dad is saying he doesn't remember this happening. They don't assert that there's any text messages or anything else that she might have to incriminate Diddy, like, hey, you better not tell him about what we did in a text message. They don't really have any evidence. So whatever evidence they have, they can probably hold it in a small file on a thumb drive and it will be preserved versus terabytes. What was it? 25 terabytes that Diddy had in his criminal case. It's not that much evidence is what Jay-Z is arguing here. So it's not a burden for them to hold on to this evidence. They go on to jump into a little bit more of why they want the motion, or sorry, the complaint against them struck. So this whole time, the motion has been to preserve evidence and to strike Mr. Carter, aka Jay-Z, from the First Amended complaint. Tell me why we only got one paragraph of information of why he needs to be struck from the complaint. Majority of this document, which is 20 pages, has been about how Buzbee sucks and how he didn't do his job. But also, we want this dismissed as well. I thought they would focus on this a little bit more rather than the preserving of the evidence. I don't think we need it. I mean, I guess they had to argue the rules. But even in arguing that it needs to be struck, they don't cite any rules of why it needs to be struck. They just say a couple of facts and a couple of sentences. And like I said, it took them a while to file this. I thought this section would be a lot more complete than what it is. So what did they say? The court should strike the complaint against Mr. Carter pursuant to Rule 12F. The revelation from the NBC interview not only demonstrate a substantial risk that discovery will be destroyed, but also that the First Amendment complaint should be stricken under Rule 12F1. The First Amendment complaint alleges that Mr. Carter committed heinous acts, but as described above, those allegations are baseless and fatally contradicted by plaintiff and her father's statements to NBC. To say that these allegations reflect unnecessarily on Mr. Carter's moral character is a gross understatement. Striking a complaint, this is just the ruling. In this case, they're citing, struck the complaint on the court's own initiative because racist and needlessly inflammatory language in plaintiff's complaint was immaterial, impertinent, and scandalous. The salacious allegations against Mr. Carter serve no purpose other than to harass him and to pressure him to settle a lawsuit based on false claims. The court should dismiss the plaintiff's entire First Amendment complaint at minimum, strike the allegations contained therein referencing Mr. Carter, and dismiss him from the action. In conclusion, they want the evidence to be preserved and they want the whole First Amendment complaint to be stricken or at least strike the allegations made against Jay-Z. Now, they want to dismiss it under Rule 12F of the Federal Rules of Civil Procedure, but they don't cite it and they don't tell us what it is. And I don't know that off the top of my head because I don't practice in federal court. So let's see what they're actually asking for it to be dismissed. What's the basis of them asking for it to be dismissed? What the heck is this? Okay. Let's see. 12F. Motion to strike. The court may strike from a pleadant an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. The court may act on its own or on motion made by a party either before responding to the pleading or if a response is not allowed within 21 days after being served with the pleading. I spoke too soon. They did actually cite it, but it was way up above. They didn't recite it in the argument section. So motion to strike from the pleading, an insufficient defense of redundant, immaterial, impertinent, or scandalous matter. So he's saying that the allegations that he did the SA to the girl is scandalous, which is they defined as just kind of attacking someone's moral character. I don't agree that that's just attacking someone's moral character. It's actually accusing them of doing something. Maybe under impertinent, they can get it stricken for that. Because basically what Jay-Z is trying to do is argue the case before it actually goes to trial. They're basically trying to deem her facts as incorrect. Like we know with a motion 12B6, failure to state a claim, is that you're not actually alleging any wrongdoing. He can't ask for it to be dismissed under that because she is alleging wrongdoing. He's just saying that the alleged wrongdoing is false. I'm not all the way familiar with a Rule 12F motion to strike and whether the falsity of the claims is relevant or whether they're true or that they can be proven is relevant. But just based on reading that, unless I don't know what some of these words mean, and they didn't really say under which one they're arguing under other than the fact that it's scandalous in their opinion. Yeah, impertinent doesn't even fall under that either because it's just not showing proper respect or being rude, which, I mean, if you did that, you can allege those things. So I don't know if there's a way to dismiss a case before we actually get into discovery because you think the person is lying, right? Of course, a motion to strike comes before filing the answer, but I don't think this all the way fits just dismissing it because she's not going to be able to prove her case. Now, you can do a motion for summary judgment after the response, but you can't do it before the case starts. So that's an interesting way. I could be wrong because I don't practice in federal court and we don't really do all these kind of motions in family law. We can, but they just don't come up often. But I don't think they can do this. And that's why I said at the beginning of the stream, is Jay-Z innocent or is he just deflecting? Because is he just trying to embarrass Buzbee so much that he just withdraws the claim? Because under these rules, I don't think he can win on what he's requesting. I could be wrong. Like I said, I don't think they cited enough stuff to prove why the court can dismiss it for this reason. Claiming that you did something sexual to someone, and if she can prove it, then that's not scandalous, right? He's basically saying she can't prove it, so it is scandalous. I guess I'm trying to work through it, y'all. I'm trying to work through it with y'all. I guess that's what they're saying. Since she can't prove it, it's scandalous. I guess, but I don't think you can do that. I think you gotta wait till the motion to summary judgment. I think you have to wait until some discovery. You can't prove your case. Let me know what y'all think. Do y'all think it should be dismissed because he's arguing the case based on an NBC article, which is going to be considered hearsay. You're going to have to pull those people that interviewed her to testify, yes, she told me these things. Because a news article that you're reading online is hearsay. You can't just admit it unless her attorneys agree for this news source to be admitted. Because remember, the interviewer is just given what they heard. And they put the story together how they wanted to put it together. I don't know if actually the full transcript or if a full video interview came out. I haven't seen it. Y'all can let me know if it has. But I don't think it gets dismissed under this. I think it scares Buzbee and he withdraws some things. But I don't know. I don't think it'll get dismissed under this. Y'all can let me know what y'all think about that. But before we get into the chat, y'all, we got a little bit more to go over. So remember, Jay-Z is accusing Buzbee of doing some inappropriate things to his own clients. And his own clients within the last few weeks have been suing him left and right because of the misconduct. So I'm just going to read one of them because the other one is pretty repetitive and the other one is talked about within both of them. Seems like it's the same law firm suing on behalf of similar clients. So let's go ahead and jump into the first one. And, we got creative language as always, right? Creative language. Let's see. Where's Bossy? Y'all, Bossy B has only been making 1 or 2 appearances per stream. She's only making a few appearances. So we have a lawsuit that Jay-Z has attached claiming that Buzbee not only is doing misconduct in this case, but he has also done misconduct in several other cases. And he actually has 2 recent cases that was filed within the last 2 weeks of his misconduct. And then he has another one filed because of assault that he allegedly committed against his own client. And that was filed back in November, which is ridiculous. Absolutely ridiculous, but it's here. It's here. So this is for plaintiff Adam Guidry. I hope I'm saying the name right. It's suing Buzbee and his law firm. They start off strong. Tony Buzbee and the Buzbee law firm, represented by Adam Guidry, a U.S. Coast Guard licensed ship captain who was severely injured on the job. The Buzbee defendants told Guidry his case was worth $1 million, but later coerced him into settling for less than 1/3 of the amount. In insisting that he settle, Buzbee's defendants never explained Guidry's options, never discussed the pros and cons of trial versus settlement, never disclosed mounting expenses, and never disclosed the meager amount Guidry would receive at distribution. Instead, Buzbee's defendants told Guidry he had no choice. Guidry was vulnerable. He had lost his job as a result of his injury. He was financially destitute. His marriage had failed, and he was struggling with addictions, relying on his lawyers. Guidry accepted the settlement offer. Now, what else did we notice about the person that is suing, the accuser that's suing Jay-Z and Diddy? She also seems to be a vulnerable person, someone who has been, at least what her father can attest to, at least essayed once in her life, right? And then she's also accusing she had another incident with Diddy and Jay-Z. But for at least, for a fact, we know at least once that can be corroborated by her dad. And she also had a head injury in the past. To me, that would be somebody that would be considered vulnerable. They also said that she was homeless at one point. That's someone that's vulnerable. This man has been injured. He needs money. He needs help. And he's claiming that Buzbee took his money and left him with nothing. Right? I would feel so bad. And I did personal injury for a while, y'all. I feel like I've been in so many job areas, but I've done personal injury for a while. And this number that they are giving, even if the expenses are high, as a personal injury attorney, you should cut your losses and at least give your client at least what you're getting, right? You have to cut your losses sometimes because maybe you spent too much money and it's just a loss for you. You shouldn't let your injured client suffer. Y'all, listen to how much money he got. Listen, when the settlement funds were dispersed, Guidry was stunned to receive only $5,123.19. Add that 19 cents in there. The Buzbee defendants had taken 98% of Guidry's final disbursement and 74% of his overall settlement. The Buzbee law firm deducted $53,000 in fees and $266,876.81 in expenses, in quotation marks, including $90,920 for expert witnesses' fees. Remember, we talked about we can pay witnesses. Experts usually have a certain amount. You probably are not looking at paying less than $10,000, depending on what kind of expert they are, right? $5,000, $5,900, almost $6,000 in postage and copies fees. So we already got $6,000. Then they added another $9,763. So almost $10,000 for more copies. So they charged him $16,000 for copies and postage, I guess. And then $9,493 for attorney travel expenses, and adding insult to injury, $150 for closing fees. Y'all couldn't have waived the $150. Y'all could not have waived that. You needed that $150. That's messed up. Moreover, the Buzbee defendants deducted $25,723.42 in fees and expenses for a referring attorney who, despite promptly handing off Guidry, claimed he accumulated $4,523.42 in expenses. So what happened there is he probably went to a different personal injury attorney, and the personal injury attorney couldn't take the case where he wanted it to go, which was probably trial. Maybe this personal injury attorney didn't do trials, right? And so they referred this client to Buzbee's firm. And essentially what happens, why can I not think right now? Essentially what happens is, since he did some work on the case, he gets a percentage of whatever Buzbee gets. So he gets a fee percentage of whatever the outcome is, plus he gets whatever expenses he incurred while doing the case. So they're saying he incurred $4,500 worth of expenses, and then he also got a percentage of the fees for a total of $25,000, which is likely he probably didn't do that much work on the case to receive that. But I mean, with contingencies, sometimes you don't have to do a lot of work to get a lot of money, right? Worst of all, perhaps the Buzbee defendants charged Guidry $23,571 in interest on $85,450 in loan. So they loaned their client $85,000. and then they put interest on top of the loans. And wait till y'all find out where the loans came from, okay? The rules of professional conduct requires fairness and transparency in any financial transaction with a client. Even then, the amount of interest a lawyer can charge a client is limited. The Buzbee defendants kept Guidry in the dark as his loans grew by 27%. This exploitative practice not only violated ethical standards, but also compounded Guidry's financial hardship and vulnerability. The Buzbee defendants breached their legal and ethical duties to Guidry, along with Jane Doe's 1 through 10. The Buzbee defendants unjustly enriched themselves at Guidry's expense. Such conduct would be unethical in the standard business transaction. It is unconscionable in an attorney-client relationship. So he was awarded in his settlement about $300,000. I think it was like $325,000. We'll get to that number once we get into more of the facts. About $325,000 is what he was awarded. He walked away in his pocket, money in his pocket, $5,000. Could you imagine? And he's the one with the personal injury, not Buzbee. How did you incur $230,000 in expensive and y'all didn't even go to trial? Or I guess they did go to trial because they had expert witnesses, unless they paid the witness. No, they said it was a settlement. They said it was a settlement. So you didn't even make it to trial. And you incurred $233,000 in expenses, including $90,000 on expert witnesses? Why didn't you settle before you set it for trial? These big companies, they have those $1 million policies. He was probably entitled to that $300,000 in the settlement phase. I would love to see what discovery comes out in this. This case was just recently filed, so there's not a lot of information on it yet. Let's get a little bit deeper into the facts. Let's break it down a little bit further. Tony Buzbee is a relentless self-promoter. Ooh, not more people attacking Buzbee. The Buzbee defendants rely on Tony Buzbee's quasi-celebrity status to lure Louisiana residents such as Guidry to the Buzbee law firm. Tony Buzbee draws attention to himself and his firm by representing and suing celebrities, by broadcasting his wealth on social media, and recently by parking a World War II tank in front of his home in an affluent Houston neighborhood. So he's been playing this celebrity act for a while, I guess. In 2020, Guidry was referred to Buzbee law firm. Guidry had been severely injured while working aboard the General Eisenhower. In February 2020, the Buzbee law firm filed suit against Callan Marine, the owner of General Eisenhower. And see, that's the problem. That's the problem. As a personal injury attorney, why are you filing a lawsuit 2 months in? It says he was injured in 2020, and by February 2020, they filed a lawsuit against the company. Why did you not try to go through their insurance first before filing the lawsuit? You could have got a settlement before filing the lawsuit. And for those of you who don't know, contingency fees generally are 33% of whatever the client receives. They get that off the top. And then they also charge you for whatever expenses they incurred in representing you, which might include postage and copies, which might include travel, like you saw, which might include medical expenses if you're paying the medical expenses directly to the providers. If you go to like a chiropractor or something, or like an actual medical doctor, if your law firm is paying that doctor, they will recoup that money back at the end of the lawsuit. But generally, at least in California, when we do personal injury cases, we try to negotiate first. And that tends to go on for at least a year before filing a lawsuit, because he's going to go to the doctor. We're going to write up a demand letter and say, you owe my client this much money because he's hurt, and this is all the damages that he has because you guys hurt him. And they'll go, okay, we have $1 million policy. We'll give him $500,000. You might say, okay, yeah, that's great. I'll take the $500,000. Or maybe they might have said, here, take $1 million. We don't know. But since you guys are making us go to court and go to trial, we're not giving you the $1 million. We're going to give you $300. That's the final we're willing to settle. So had they negotiated prior to filing the lawsuit, maybe, just maybe, he wouldn't have to pay us so much. Oh, sorry, y'all. I got distracted. So it's usually 33% of the fees, not including like the expenses and everything. At least in the personal injury law firm that I worked in, if you go to trial, your fees go up to 40% of what you receive in addition to the expenses. And as you can imagine, the expenses for court substantially skyrockets the amount of money the client is going to owe you at the end of it. Your expenses go up. Maybe you have to pay for lodging so that you can do the trial. You have to pay court fees. You have to pay this. You have to pay that. You're going to the doctor more. You're having to pay all of those things. So the amount that the attorney gets in trial goes up by way more once you set it for trial. But if you do settlement, you're not incurring as many expenses outside of court, right? I hope that makes sense. Let me get back into it. Okay, so they filed the lawsuit in 2020. And it could be different. I'm talking from my California experience, y'all, so don't quote me on everything. Sound like this case was in Louisiana. Despite initially valuing Guidry's claim at $1 million, the Buzbee defendants coerced Guidry into settling his case for less than 1/3 of that amount. In doing so, the Buzbee defendant failed to inform Guidry of his options, including the implications of settlement versus trial. The Buzbee defendants concealed critical information from Guidry about the skyrocketing expenses and the paltry amount Guidry would receive upon settlement. Relying on his lawyers, Guidry settled for $325,000. When these funds were distributed, Guidry received $5,123. The Buzbee defendants kept Guidry uninformed and exploited his vulnerability to unjustly enrich themselves. Now, he could have went to trial and maybe he would have got more, but maybe he would have incurred more in expenses. So that was the risk he was running, right? Based on information and belief, Buzbee defendants have a pattern of using these predatory practices against their clients. Buzbee represented Guadalupe Garza, who was injured while working on a vessel owned by Callan Marine. Buzbee sued Callan Marine in Nueces County, Texas, under federal law. Garza was entitled to receive maintenance and cure payments. According to the court filings, Callan Marine was instructed to make maintenance and cure payments to Garza to the Buzbee law firm, but Garza never received the payment. Callan Marine subpoenaed records from Buzbee law firm to find out where the payments went rather than providing records in defense of their actions. The Buzbee defendants opposed the subpoena. So they were asked to prove where the money was. So apparently with this I don't know if it's maritime law or whatever, but they have rules. They have federal rules that if their employees are injured while working during the lawsuit and while they're on the injury, that company is required to pay their employee regardless of if they win or if they don't win. So Buzbee, when he signed on to the case, he said, no, pay our law firm. We'll give the money to our client. That way we can kind of keep track to it, allegedly. That's what they did. And so the company, they did their job. They paid Buzbee's law firm the money that the client was entitled to. Buzbee did not give the money to the client, or let's go on. We'll see how else they used the money that was supposed to be going directly to the client. It's the client's money, y'all. At the hearing in the Garza case, Callan Marine counsel stated that other Buzbee clients have reported not receiving maintenance and cure paid to Buzbee law firm. So not only did they do it to this guy that's filing the lawsuit, they did it to this guy, to the case Garza that he's citing. And Garza case is saying that other people have accused Buzbee of doing the same thing, taking their maintenance and support or their maintenance and cure payment, which is outside of any lawsuit settlement or settlement regarding the entire injury. According to records, Buzbee's defendants deposited maintenance and cure payments into its operating account rather than its trust account. And the Buzbee law firm apparently repackages maintenance and cure payments intended to provide living expenses for injured workers into loans, which must be repaid with interest. Now, let's get into the different type of accounts that attorneys have. You have an operating account and you have a trust account. You use your trust account for money that is of the client, and then you use the operating account for money that is of the business. Sometimes in your trust account, some of that money might go to the attorney's operating account once the fees are earned. But as I said before, the maintenance and the cure payments are not fees that Buzbee can earn unless they're holding on to it. And then at the end of it, they use those funds to pay off their expenses or their attorney's fees or whatever it may be. But the client has to agree to that. So if the money is for the client, which the maintenance and cure payments are for the client, they should have been going in the trust account. and they should have never been transferred until after the fees were actually earned by Buzbee. What this case is saying is that Buzbee was putting the funds into his operating account and said, this is money that the firm has earned. Just for me being your attorney, thank you, company, for paying us money for our maintenance, not the client's maintenance, but for our maintenance. Thank you very much. And not only was this money the client's to begin with, y'all, it was the client's money. Buzbee then loaned the money out to the clients. He loaned the money out to them and then put interest on it. You are putting interest. You're loaning money. That's my money. It's my money. You're loaning it to me and you're making me pay interest. This is what he's being accused of. I think the Garza case actually already settled, and so I think they won in that one. And then this case is basically alleging the same thing. And then there is a similar case, which is the other one that was filed that is included. I do have a copy of that one. We're not going to go over it today because it basically alleges all of the same things. A similar case illustrates a pattern in Thompson versus Buzbee. The Buzbee law firm allegedly misappropriated maintenance and cure payments owed to Matthew Ray Thompson Jr., a deckhand injured when his vessel collided with another. Like Guidry, Thompson alleges he was kept in the dark as the Buzbee law firm ran up expenses, including high interest loans to Thompson. Oh, and that's what I was going to get into. So not only were they loaning the client's own money out to them and charging them interest, which they took out of what he was awarded, right? They're also racking up these expenses and not telling them like, hey, this is getting pretty expensive. It's going to result in you only getting this much money. You should keep your client updated of like, hey, this is getting expensive. You're probably only going to get this much. When I did personal injury, I was in the negotiation parts of things. So anytime we got an offer from the insurance company, we had to do a whole breakdown and say, okay, darling, these are your expenses. This is where your expenses are. This is where this is. This is how much they're offering. If we agree to the settlement, this is the net amount that you would get because you have to pay off your expenses each time a settlement offer. So if it was like, okay, you're only going to get $5,000, the client can go, no, I need more. No, I need more. You need to negotiate for more. And they were not giving their client the opportunity to know where their expenses were to show the client like, hey, if you accept this offer, you're only going to get this amount of money. I'm sure if they told him, hey, if you accept this offer, you're only going to get $5,000, although the face value of the money is $325,000, you only get $5,000 of it. I'm pretty sure this guy would have said, no, I don't want to accept that, right? Has to. I wouldn't accept it. Y'all let me know if y'all would accept it. Okay. In another case, Callan Marine moved to designate Buzbee, the Buzbee law firm, and Chris Liviet, an attorney at the Buzbee law firm, as responsible third parties for maintenance and care at Callan Marine paid. I skipped the whole line. Responsible third parties for maintenance and care that Callan Marine paid, but its client, Laquel Teener, never received. In Texas, they filed this one in Texas too. In its motion, Callan Marine stated, in connection with these contested allegations, but in compliance with its obligations under the Jones Act, defendant Callan paid maintenance and cure payments to attorney Buzbee. These funds, which even included some of Mr. Tyner's unearned advances, were paid to the Buzbee firm because that was following their demand. So Buzbee is the one that asked for this money to be paid for him. Callan was unaware that they were not getting the credit that was due, or that these payments were being converted by Buzbee firm to appear as tokens of their own generosity. So they were taking the money that was the client's money and saying, oh, don't worry, client, I'll loan this money to you, even though it's not their money to loan because it's the client's money to begin with. And so Callan is basically calling them out and saying, oh, they were pretending like they were being generous to their own clients when they were really stealing from them. It is clear that Mr. Tyner alleges in his pleadings that he did not receive all funds he thought were due from Callan and that he was harmed by the conduct. What Mr. Tyner did not know was that it was his own lawyers that were intercepting the funds and that his own attorney failed to place them in the IOTA account. That's the trust account we just talked about. It's where the client money goes. Even worse, these same attorneys have attempted to conceal their own shameful conduct and transform it into a larger damage award for their client. So they're asking them to pay the loan back, right? That's how my guy is ending up with only $5,000, or part of the reason, right? It was the conduct of the responsible third party that created the lawyer-induced disappointment of Mr. Tyner in his employer, Callan. It was these same lawyers and this law firm who failed to protect said funds in the IOTA account and distribute them properly to Mr. Tyner. So this has happened. This has happened multiple times. Just in reading this complaint, we have about 5 victims that this was done to. Isn't that ridiculous? I think Jay-Z is embarrassing the heck out of Buzbee. I would be embarrassed. They go on to cite that same case of where he changed venues because the judge ruled against him on something, or they called him out on something. They say Tony Buzbee's misconduct apparently is not limited to client finances. According to a news report less than a month ago, Tony Buzbee flew into a fit of rage and physically assaulted a client that he was representing in a divorce. The client alleges that after Buzbee assaulted her in public, his focus became concealing the assault rather than protecting her interest in the divorce action. And so that's the other case that Jay-Z attached to this motion, saying that Buzbee is just, he does misconduct all around. He's misappropriating funds and he's beating up his clients, is what Jay-Z is alleging, right? And he's already alleged that he's made false claims against multiple other celebrities, including himself, trying to extort him, right? Embarrassing the mess out of Buzbee. So they're suing for breach of fiduciary duty. Basically, they're supposed to protect the client's funds, keep them reasonably informed. Unjust enrichment. They're taking his money and using it for their own benefit and then charging all of these expenses without really detailing what the expenses are. They're giving them loans from their own money and then putting interest on it. They then get them for negligence because they could have told the clients about this and maybe the client would have made a different decision. And then they have, of course, the regular request for relief, including the attorney's fees. What do y'all think? Buzbee sounds horrible. And I'm saying that, yes, I read one, but there's another one that's almost identical to this. He did the same thing to someone else. As we see, they cited several cases, not just of similar cases just around that has happened to other people. These are cases against Buzbee, where clients have, I believe, one, I could be speaking too prematurely because I haven't looked at all the other cases, but they are older than the ones that's being filed now. So not only is he practicing in Texas, sound like he got some cases in Louisiana, sound like he got some cases in California, sound like he got some cases in New York. He's all over the place. I don't know how many other places he's licensed, but it sounds like he's all over the place. And he's being just as janky, allegedly, in all the other states. It's not just New York that's getting janky Buzbee, okay? Janky Buzbee is around. Is what these lawsuits and what Jay-Z is accusing him of. Y'all let me know. Is Jay-Z innocent or is he deflecting? Is he deflecting to just get Buzbee in trouble? Let me know. We're going to jump into the chat now. So if y'all got comments, go ahead and drop them in the chat. If you're on the replay, drop them in the comment section. It just gets messier and messier. Jay-Z has it very messy for us. We're doing kind of good with the likes. We're at 33 likes with 33 people watching live. So if you haven't hit the like button, please do. I know some people have come in and out, so I'm sure there's some of you that have not hit the like button. It definitely helps the channel out if you hit the like button, and it's free, and we like when you do it. So please do hit the like button. Anyways, let's jump into the chat to see what people have to say about these cases, or this case against Jay-Z. Do we think that this case should be dismissed against Jay-Z at this point? I would say no. Otherwise, I think he would have been able to file 12B6, failure to state a claim. But arguing whether the facts are true or not is premature, in my opinion. And don't quote me on this because I don't do this motion type of practice on a regular basis. I could be wrong. But my understanding is even in these motions to strike and motions to dismiss, the court has to view the facts most favorable to the plaintiff, most favorable to the person filing the allegations. And defendant cannot just say this person is a liar. Otherwise, we would have no lawsuits, right? If you present all of your evidence of why this person is wrong, No lawsuits will make it past the motions period, right? Before the answers. No lawsuits will make it past that. So I just don't see how we would dismiss it at this point. Yes, when we get to motion for summary judgment, I forget what the other ones are called. I forget what the other ones are called. There might be something before a motion to summary judgment in the actual litigation phase. But we can't just say, oh, you're a liar. We have to dismiss it. My understanding. I could be wrong. Don't quote me. I'm a lawyer, but I don't do everything, okay? I don't do everything. Y'all heard me explain a lot of stuff that I know about, but I don't do everything. Okay, let's see. We got Denny says, I agree he's doing too much. Which one? Which one? Yep, another Maria says, I love the name. I'm a little bit of a Jay-Z fan, took myself to a show, and so biased until the facts. I agree that he probably will not pay in the end, right? I don't think she can prove her case in trial. I just think it's a little bit premature to dismiss at this point. Yep, another Maria says, oh yeah, everyone involved by proximity from lay perspective. Denny says, how could her father forget his 13-year-old daughter calling him in distress from a gas station in a different city? I don't think you would. I think the father was completely right in saying, I don't remember that. And I think I would remember that. I think any father would remember driving 6 hours to pick their kid up in the middle of the night or at dawn, right? He had to start driving in the middle of the night to get there at dawn. Denny says, and apparently the friend that took her to New York is unalive. Yeah, we can't even talk to that person because that person no longer exists. Won't be able to testify. Her dad is not going to be able to testify in her favor. And you know what doing that interview did? Even if she decided not to call her dad as a witness, now that they know the dad is going to testify against her, guess who's going to call the dad as a witness? The defense. The defense is going to call the dad as a witness. And if the dad gets up there and lies and say, oh, no, I did pick her up, I just forgot at the time, they're going to impeach him for an inconsistent statement. Inconsistent statements, right? Destined to be member and moderator of the channel, welcome in, said, this is your friendly reminder to hit the like button if you haven't yet. Bossy B appreciates it. Thank you for the reminder because I forget. I forget a lot. Thank you. Celebrity Scandalous says, why hasn't judge dismissed the case or dismissed Jay-Z yet? The court hasn't done anything on any of Jay-Z's motions yet. Like, they literally have not had a hearing. This motion, Jay-Z was asking to have an emergency hearing for today. That does not look like it happened today. So like we talked about in previous live streams, he wasn't even served. He started participating in the case before he was served. So the court may still just be catching up. They may be waiting for him to actually be served with the complaint rather than him just pulling it from online, right? And then they'll start making movement. This case is probably not going to go very far because Diddy is in jail and he has the right to plead the fifth until his criminal charges are resolved. Because these things can come up because she's accusing him of doing stuff similar to what the prosecutors are accusing Diddy of doing to Cassie. So the judge hasn't dismissed the case. It's too early on. I still don't even think even after this motion is going to be dismissed. I think they're going to make it so that she can't be anonymous, and then Buzbee's just not going to file it again. Loyal 12-9. I feel dyslexic a little bit right now. Loyal 1229 says, yeah, this claim/allegations need to be dismissed. It's a waste of time, taxpayers' money, and I hope Buzbee gets sued for this. He is already getting sued by Jay-Z for this. I don't think it's going to be dismissed this early on. Y'all, let me know if y'all don't agree. Let me know if y'all don't agree. I don't think she wins, but don't get me wrong. I do not think that Buzbee wins this case. I just don't think that is going to get dismissed this early because of the process that the court has to go through. Loyal says, I would think it could be dismissed because it wasn't vetted properly and therefore shouldn't have been brought up to the court, and Buzbee can't practice in New York. He can practice in New York. He's just not registered with the court. So he is licensed in New York. We did look it up on the channel. He is licensed. He's just not licensed in the court. When you're practicing in federal court, you basically have to take an oath for that court as well. In addition to your regular bar, being admitted to the bar oath, you have to basically apply for admission to each particular federal court as well. You also would have to apply to be able to practice in the Supreme Court. Like me, I don't have any admissions into federal court or the Supreme Court. If I wanted to practice there, I would have to apply to it before they could really accept anything that I file in there. So he is licensed in New York. He's just not admitted to practice in the federal court there. And I would agree with you. I said it's too early to be dismissed. But what I did skip over, so y'all gotta scratch out everything I've already said. I think it's too early to be dismissed on the motion to strike. But I do think that it could be dismissed on the Rule 11. Well, let me look it up before I start talking. Let me see. I think he can be sanctioned, but I don't know if you can be dismissed for Rule 11. Federal. And y'all don't be quoting me on these things. I don't practice in federal court, so all of this, everything I try to talk about regarding federal stuff is from law school 5 years ago. So don't quote me on everything, right? Let me see. Sanctions. Nature of sanctions imposed under this rule must be limited to what suffices to deter repetition of conduct, comparable conduct. The sanctions may include non-monetary directives in order to pay a penalty to the court, or if imposed on a motion and warranted for effective deterrence, in order directing payment to the movement of the part or all reasonable attorney's fees and other expenses directly resulting from the violation. And so actually it looks like with Rule 11, okay, here we go. Limitations on monetary sanctions on its own, unless it is issued the show cause order from Rule 11C3 before a voluntary dismissal or settlement of the claims made by or against the parties that is, or whose attorneys are to be sanctioned. Yeah, so it looks like the court cannot dismiss it on that, but he can voluntarily withdraw. He can voluntarily withdraw it. Yeah. So it's mostly monetary sanctions, but they can voluntarily withdraw. So no, I actually don't think it will be dismissed on Rule 11 either. I think it's too early to be dismissed. So a celebrity scandalist says no, she spoke though. Who spoke? J-Lo? Zoe B, another member of the channel, welcome in, says, how does any person go to an after party, then flee, presumably on foot, to a gas station? Yeah, it would be on foot. To a gas station to call for a ride home, and that ride arrives near sunrise when they supposedly came from hours away. I think that would make, well, I don't know if it's an after party. That's where the discrepancies start to come in play. The timelines don't add up. I think they are completely right with that. Like I said, I don't think she wins. I don't think she wins. I think it's just too early to be dismissed. Zoe B says there's enough hours for all that to happen by around sunrise, unless the after party started at 5 a.m., which would be the same time as senior citizens' early bird special. Thank you for that. I don't think the timeline adds up, because if she went to an after party, well, it depends on what time the after party started, right? Or what time the regular party started. So for the after parties. For all we know, they went to the after party while the VMAs was still going, and they went home by 12 a.m. Like, we don't know. We really don't know. But the fact that doesn't line up for me is that the dad doesn't remember driving that far. And she specifically said the dad drove that far. Just Stacy says the story doesn't line up for me either. It doesn't. Lael says senior citizen early, the early bird one, that was funny. Lael says, it doesn't add up to me either. I'm from Rochester, New York, and that's a good 5.5 hour drive. So 11-hour round trip with them being teens with no GPS. It probably took 6 to 6.5 hours to get there. And we can't even ask the person that drove. And then the dad doesn't remember driving to pick her up. That would be memorable. Driving 12 hours to get your rebellious teen. Yeah, that would be memorable. Just Stacy says, I'm by Los Angeles County. That drive, you would remember, traffic is atrocious here too. Yep, you would remember. You would definitely remember that. Just even if you don't remember the day or the year, you would remember one time my rebellious teen snuck out and went to Diddy's party. Well, she didn't tell him where she was, but snuck out and went to New York City when we live in Rochester. And I beat her butt when she got back, or whatever it might be, right? I was so mad at her. She was grounded for 10 years after that. You will remember that. Just Stacy says, touching the client account is a no-no. Exactly. Unless the money is earned, you cannot transfer that over. Zoe B says, Buzbee is sounding eerily like Alec Murdaugh in terms of taking money from clients who are vulnerable. It also sounds like Tom Girardi, does it not? It does. Not me answering my own question. Things to Afromine says, Buzbee represented the AG here, Attorney General here in Texas. Represented the AG here in Texas. I wonder how and if that will affect that trial. I don't know. He already got in trouble with like potential bribes to a judge, according to Jay-Z. Okay, I haven't vetted these, but according to Jay-Z, he's already gotten in trouble with bribes to the to some judge, to where they had to take all of his cases away from that judge. And I believe the judge was also then dismissed. I have to reread it. I might read it on the stream because I do have the complaint for extortion that Jay-Z filed in California. Just Stacy says, and Girardi, LOL, I spelled that wrong. Yeah, okay. I was like, let me make sure I'm not messing stuff up because y'all know I'm stuttering already. Judy Mott says, Buzbee fighting for his life. Yeah. Oh, Jay-Z is throwing daggers. Like, this is not even about the case anymore. Jay-Z is throwing personal attacks at this guy, probably hoping that he just gives up on the allegations and just say, you know what, let me crawl in the hole. My tenure at being a quasi-celebrity attorney is over. I would quit. I would curl into a ball and cry. First of all, I would probably do that if one client sued me. But if you're telling me multiple clients are suing me for the same thing and saying I'll be stealing money, I would have been curled up in the ball. I'm not going to go out and try to sue Jay-Z and Diddy. Like, my time is over. Once you start getting sued by clients, your time is over. Don't go and try to sue the most famous the most famous celebrities after that. Like, he is putting all your dirty laundry, like, just out. And people, like, Jay-Z's attorneys is probably not even doing the research, y'all. They probably got people coming to them like, Buzbee sucks, here's this lawsuit. Buzbee sucks, here's this allegation. Buzbee sucks, look at this. The FBI investigated. They probably don't even have to do research. People probably giving them the case numbers. Like, Buzbee, I would quit. I would never be an attorney again. You should have enough money, go retire, run away. Don't run away from your responsibilities. A lot of people are suing you. But I just couldn't do it. I would give up. Maybe I'm too sensitive. Things to Afromine says, I definitely believe it. There's always a lot of lawful isn't always right. Things happen here in Texas. Makes sense. Kimmy Lockett says, lawful and ethical are two very different things. Yes, that is absolutely correct. Denny says the accusation against Buzbee are irrelevant. Him being a crappy lawyer doesn't mean Jay-Z is innocent. Yeah, and so that's why I say, is Jay-Z innocent or is he deflecting, right? I would agree that I don't think that this case goes to trial. I don't think it wins. I think it's going to get dismissed somewhere. I really am trying to think of the other words other than summary judgment. There is something else. There are other places where you can get the case dismissed for not having enough information, not being able, after discovery. What is it called? I can't think of what it's called. I'm going to have to look it up after the stream. But I don't think all the way that the allegations against Buzbee are irrelevant, because technically it goes towards his request to preserve evidence. But also, do you need a request to preserve evidence knowing that they don't have no evidence? I think he took it as an opportunity to throw shade. Like, I'm not going to lie. I think he's taking it as an opportunity to throw shade. Like I said, I think this is too early to dismiss, basically saying, oh, court, please rely on this hearsay from this NBC article to prove why her allegations are not true, because she said it. You're going to have to get her on the stand and say, why did you say this in this interview? She can say, I didn't say it in the interview. That wasn't me. She can easily say, that wasn't me. That was someone pretending to be Buzbee and me. It wasn't me. So I don't think they're dismissing it off of, look at this hearsay article. This proves that her claims are wrong. I don't think he gets there. Judy Mott says he also was convicted of drunk driving. I did see that. I don't know if that really reflects on him sucking as an attorney versus sucking just as a human. Don't drink and drive, people. It is dangerous. Harper Polo hit the like button. Thank you very much. Welcome in. Nice to see you again. All things Netta Jean says the dad knows the daughter is lying, or at least that she doesn't remember correctly, right? She had a head injury. I don't know if I think she's all the way lying. I think she's mixing up timelines, mixing up events, because the dad does say that she was SA'd by someone later in life. But I think she might just be mixing things up due to the head injury. I'm not just going to come out and call her a liar. So he isn't trying to get implicated in her lies. Yeah, he's not. Because he don't want to go to jail for perjury for a potential couple $1,000. If anything, as much as Diddy's being sued, how much is going to be left over if all of these people win? Not a lot. I mean, I guess that's why they added Jay-Z in there. Judy Matt says, why is nobody talking about a 20-year-old driving a 13-year-old 5 hours away to fulfill her bucket list? A 13-year-old with a 20-year-old friend and has a bucket list. That is also interesting. I noticed that fact, but you're right. I haven't talked about it. I haven't heard anybody talk about it. I think we did talk about it very briefly on Sunday's stream. It's like, why is a 13-year-old hanging out with a 20-year-old for one? Because I was like, she would not have any friends that would be experienced drivers enough to drive 6 hours. But now she's claiming that the friend that drove her was 20 years old, maybe a family friend. But what 20-year-old, if mature, maybe not too mature, because you're driving a 13-year-old to the VMAs and she doesn't even have a ticket to the VMAs, and she's sneaking out of the house, and then just drops her off and leaves her in New York City? Has this girl ever been to New York City before? You're letting her get in a limo? This is a time where everyone did not have cell phones at this time. Like now, a 13-year-old might be able to go an hour on away and call an Uber back home, right? But back in 2000, people didn't have cell phones like that. And I'm sure this 13-year-old didn't have a cell phone. Maybe she did. Let me stop adding facts in there. No, but it sounds like she didn't have a cell phone because she had to use the gas station phone to call her dad. So yeah, no, that is definitely a strange fact that's being presented. Joshua Boone says a Buzbee is also being accused of assaulting a woman who was his ex-girlfriend / client. Oh, they didn't say it was his ex-girlfriend. It just said that it was a client. And she was a divorce client. So he was dating someone that was married? That would be strange. But no, yeah, I do have that document as well, the summons for that as well. But I'm just not going over it because we mentioned it in the lawsuit that we just covered. It was very short, but we did mention it. Things to Afromind says, are you talking about deferred judgment? No. Deferred judgment, no. I'm looking up ways. Love Google. I'm not even on Google. I think I'm on Bing. Ways to dismiss cases due to lack of information. Yeah, I gotta look it up because now it's bothering me. It's not a deferred judgment though. Legal request to dismiss lawsuits. I don't know if I'm even searching the right thing, y'all. Not motion to dismiss. Deferred something does sound correct, but I don't remember. I really don't. I'm gonna have to go find my law school note. Lawsuit other than summary judgment. Sorry for y'all that don't care, but now it's in my head. I don't even know what to look up. They're doing voluntary dismissal. My last one. I'm really trying to find it now. So they're doing the submission for the motion before the response. That's what he's doing right now. But motion to dismiss guide for litigators. Let's see. Okay. I think I know what to look up, but I don't want to keep staring at the screen while y'all on the live. Procedural. I think it's just procedural. I keep trying to use like this little AI. I don't think I'm gonna find it. Now I feel defeated because I really don't know. Failure to state a claim. We already know about that. I don't know what it is. I'm gonna have to go into my civil procedure because we don't do those kind of things very often in family law. So I really don't remember what it is. But something with a D does sound familiar, but I cannot think what it is. And now it's gonna bother me. Just Stacy says, when gas stations still have public phones? LOL. I think so. I think they would have had public phones for sure. Kai Mystery says Spiro is flipping the script to make Buzbee the defendant. Yeah. That is exactly what is happening. I didn't think of it like that, but he definitely is. This case is now about Buzbee. Like, you better effing leave me alone, and you better not ever do this again. Like, you have to crawl up in a ball and die at that point. Harper Polo says random, but I think it's weird that Singing Twins said they weren't at the 2000 VMAs, but didn't say they weren't at the after party. They did say they said they weren't even in New York at the time. They said they were in the Midwest. So I don't know if they would feel the need to mention the after party if they weren't even in New York. So I don't think that is that weird. Anyways, y'all, that's all I have for the live stream. I'm still struggling on the procedural moments of where you can dismiss lawsuits. Oh my gosh, I know I'm not going to have the notes and I know I'm not going to be able to find it. Anyways, I know some of y'all knew that I was in trial or supposed to be in trial towards the end of this week, but the trial got canceled due to what I believe to be lies, but it got canceled and we're going to reschedule it for a later date. So I was able to stream today. So that's why you guys are seeing me. Otherwise, if the case was going forward, you would not see me today, but I'm happy that we were able to jump on live and chat about these new filings that have been made. I think we may go ahead and cover that California case that Jay-Z filed against Buzbee for the extortion, so that we can see all the other claims, all the bad things that Jay-Z is claiming he did there. All of these lawsuits are about attacking Buzbee at this point. Like I said, I don't think Lady wins the case, but I do not think that it gets dismissed at this point. I'm going to look up what the procedural when can you move to dismiss the case? I know this one, that's what they're doing right now, is the motion to dismiss before we even get into everything. Let's try to get this thing dismissed. Definitely understand that. But there is another one before it goes to trial. And then there is one during trial. And so I just got to figure out what those motions are. I'm going to figure it out. Anyways, I don't know when the next live stream will be. If I have time on Sunday, maybe I'll do another Sunday live stream. That was fun. And then if y'all got cases that y'all want to cover, let me know what those cases are. And I don't have trial next week, so I should be able to stream a lot more next week, other than the holiday. Oh yeah, I forgot that it's Christmas as well. So maybe not as much, but hopefully after the new year, we will get into more of a consistent schedule that I can actually follow. And anyways, I'm rambling. I will see y'all all on the next live stream. I hope everyone has a wonderful weekend, and I will see y'all next time. Bye.